She came out.
So you had just walked out of your house onto your porch,
Judge, has been asked and answered.
It is. Go ahead.
and was that the first time you saw Miss G with what you believe was a taser?
Yes, because she's acted at me.
Hold on, if you could just answer the questions that I asked you, please. When did she zap it?
She walked outside. She walked outside screaming, talking about she had a gun in the house. She was going to shoot me with it, and she had the taser in her hands.
Whoa, did you catch that? The witness just escalated this from a neighborhood argument to an alleged deadly threat in seconds, mentioning a gun and a taser. That immediately changes how prosecutors frame the danger level in court, and notice the judge's body language here. This courtroom is already getting tense.
And she's acted 3 times that day.
Okay, that was when you came out of your house.
Yes.
So
Your Honor, excuse me.
where was it?
I'm being distracted by the.
I'm going to put you in the lockup.
And there it is, the classic courtroom warning shot from the judge. I'm going to put you in lockup. Translation. This judge is not tolerating side commentary, distractions, or chaos today. Courtrooms run on control, and once spectators start interrupting, judges shut it down fast.
If you can't sit there without making any noise, you'll be removed from the courtroom. Do you understand that?
Okay, so my question really was, when did Miss G threaten you with the taser? Was it before you went into your house? After you went in, you came back out of your house, both?
She said she stepped out of the front door onto the porch. Your client came out and they had the confrontation on the porch.
If I may.
No, you can't.
Oof, did you hear that shutdown? No, you can't. The judge is basically telling defense counsel, stop repeating the same question and move the case forward. In legal terms, the court wants new information, not recycled testimony, and honestly, you can feel the impatience building.
I got 6 exams today and I don't need to hear the same stuff 4 times. Ask a new question that elicits new information.
Okay, where was Miss G when she threatened you with the taser?
On her front porch.
Where in proximity to your house is her front porch?
Like
6 or 7 feet away. Sit down. You're done with cross. Do you have any redirect?
No, wait a minute.
Thank you.
I'll put my objection on the record.
Feel free. Any other witnesses? Any defense witnesses?
Now this is the heart of the legal battle. Prosecutors are arguing fear plus a weapon equals felony assault, while the defense is trying to downgrade everything to a misdemeanor. That distinction matters big time because felony charges can completely change someone's future.
Any argument?
Yes, Your Honor. The witness testified a taser was pointed at her distance of 6 to 7 feet. She was afraid, actually fearful for her life. Thank you.
Your Honor, we don't believe the elements of felony assault with a felonious weapon that occurred here. We believe, if anything, the charges should be dropped to misdemeanor assault. And we ask that you would find that the prosecutor did not meet his threshold for a preliminary exam and would not find it so. Thank you.
Because there was no testimony about a felonious weapon?
Your Honor.
Okay. This moment is wild. Even the terminology is causing confusion. The judge asking, what's a felonious weapon, is basically exposing how messy legal wording can get in real time. Lawyers love technical definitions because one tiny interpretation can decide whether a case survives or collapses.
I'm not familiar with what a felonious weapon is.
I would have gotten into more details regarding what our lovely complaining witness perceived the weapon to be. I will reserve that argument for circuit court. I don't believe that it's a felonious weapon in this case.
Okay, I don't even know what a felonious weapon is. Is that the same thing as a dangerous weapon?
I don't believe that it meets the definition of a dangerous weapon, making this a felonious charge.
Okay. Bound over. AOI is next week, 9 a.m.
Thank you, Your Honor.
Say again? What? Oh, yeah, you can step down, man. Watch your step. What is today?
Today is the 19th.
Yeah, so 26. No. Yeah, yeah. No, she's in custody. Oh, she not? Oh, she had green on. I thought. Okay.
DOC could be dismissed, so we can pull that one and get it done.
Who? What's the name? Okay, what about Avant, the 945? Avant, 945.
I was going to get into that, but she's very close, ready to go.
Who?
Steps up in, and
Just get her in here. It's going on an hour.
yeah, stuff going on.
Who changed the date stamp today to the 20th?
I'll throw on the question, Joe, to do his problem himself. Carrie, you're right.
I know, okay.
Hey, Carrie, how are you? Better than I deserve, Carrie.
About Judge.
Appearances on Avant.
Good morning, I think that's 12:85:60, and Mr. Van, Mr. Dayton, and the rest of the
Good morning, sir. Counsel, you got a plea worked out? Tell me about it, please.
unlawful transport and dismissal of the original one on it,
Yeah, we only had one count, right? All right.
no comments. And I.
That was my next question. All right, sir, do you understand your rights and your options after discussing same with counsel? And you understand the possible penalty for the added charge? All right, and understanding that you're pleading no contest today, is that correct?
Quick legal breakdown. A no contest plea is not the same as saying I'm innocent. It means the defendant isn't fighting the charge, but also isn't formally admitting guilt. Lawyers sometimes choose this route to avoid future civil complications. Smart strategy. Depending on the situation.
Do you understand that when you say no contest, you're literally saying to me, Judge, I'm not fighting that charge? You understand that? All right, counsel, I've got an incident date of April 6, 2025. If you can get me the facts I need.
Thank you, Your Honor. Your Honor, if this case were to proceed to trial, the people would be able to show that on April 6th of 2025 on Ecorse Road and Harrison Street in the city of Romulus, County of Wayne, state of Michigan, that Andre Avant did possess a weapon in a motor vehicle without the proper permits or licensure to do so. And transporting that, not according to law.
Okay. Mr. Kaplan, you satisfied?
Yes, we are thinking.
Factual? Court satisfied. I'll dismiss the original count one felony. Any reason not to sentence right now?
It's something.
All right. Tell me something about your guy.
Court would consider fines and costs in this matter. My client, only criminal history is from 22 years ago. He owns his own business. He has a partner. He has children. He has been a law-abiding citizen except for it, which he's told me he was in possession of this out of state. Realized when he brought it back from that trip that the laws differ state to state, since he was able to pick this up in a gift shop. So now that he knows that, this won't be happening again, Your Honor.
Okay. What's your business? I'm sorry. Go ahead, Mr. Kaplan.
See, Kevin, thank you. At the age of 47, he has no criminal record other than these offenses that happened 22 years.
Yep. Yep. I think he just took your side.
Judge, we're recommending.
What business are you in? What do you do? Okay. Okay. Who do you deliver for? Are you one of those guys like delivers for Home Depot and stuff?
Well, whatever, yeah.
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 Okay. Okay. All right. Don't feel that you have to, but is there anything you want to tell me before I sentence you?
No.
All right. Counsel, anything else?
Your Honor, I think it's not.
I do too. All right, fines and costs are $500. Can you pay it today, sir, or do you need to talk options? Go downstairs and talk about your options. All right, felony's dismissed. Have a good day, counsel.
Thank you, Your Honor.
You're welcome. What do we got next?
Hadley is. Devontae Hadley.
And appearances on Hadley.
Stephen Kaplan on behalf of the people.
And good morning, Judge Oakley. Good morning to your staff. They were defense service Terry Markin, P. 84592, representing Devontae Hadley, sitting to my left. Hadley for.
Thank you. Sit. You're all right, sit. We holding?
I mean.
Yeah.
I'm here with Detective Mays. He has made the only like efforts to produce our witness. We're both disappointed the witness is there. I don't want to waste your time, Chuck. Would you mind if you just stated on the record the efforts he.
Yeah, go ahead, detective.
I reached out to one of the enterprise personnel people based on they were with this case. That employee no longer works there, and they had a relatively common name. Therefore, I was unable to locate them through every database that I used. The party involved, I believe, actually was a third-party contract that was transporting the defendant, and I contacted him. Did speak. He was a little standoffish, if you will, and asked me to call him back, which I did, and he never answered. So all attempts have failed. My apologies for that.
All right. Motion?
Your Honor, obviously the people are not ready to proceed. We would move for dismissal without charges.
Dismissed without. Good luck. Thank you. So
This courtroom is moving at lightning speed, one case dismissed, another already being called. That's something people rarely realize about real courtrooms, while one defendant's future is changing forever. The system keeps rolling nonstop.
On the strangler case, we've got a victim, no defendant.
that's curious too. Okay. Yep.
I don't know if we have the attorney.
Hey, Carrie. Any contact with Stringer?
She should be here. She told me she had a flat.
Ah, okay.
Yeah.
Okay. But you've been in contact.
Yes.
Okay. What about Fonville in custody, right?
He's in custody.
We're just
I don't know
waiting
if
for the attorney?
it's here yet.
Okay. All right. Thank you.
Convo is usually like.
Oh, that's right. She's a retail fraud. Specialist.
So when you redeem yourself on the bed, stand up, you can get those downstairs and we say that.